Is this you? You have your client cancellation clause in your contract and you rarely have to enforce it. And then all of a sudden, your clients start canceling left and right. What is happening? Is it something you did or is it completely out of your control? For a little peace of mind, this is something that we are seeing all over our TLP Facebook community right now, and vendors are experiencing lots of cancellations by clients. Hi, and welcome back. If you're new here, my name is Paige, and in today's video, I am going to talk about why we are seeing this huge surge in client cancellations and how you can fully enforce your cancellation clause in your contract because it is there for a reason. Let's first just talk about why clients are canceling. I have had so many people reach out lately about their clients canceling, and while I don't have every answer for you, there are probably a few key reasons why they are doing so. I've heard from a lot of you that clients are canceling due to cost. Prices of food and gas and the overall inflation rate are making clients kind of second guess the cost of their wedding and events now, and they're trying to cut down on their vendor costs. My theory is that a lot of clients are probably trying to cancel or even postpone their wedding and event date to this fall or even next year in 2023 because of inflation and their wallets hurting. Another reason that I have seen is clients who have been engaged for a couple of years and who have postponed due to COVID are now wanting to cancel due to lack of interest, their families expanding, or potentially a breakup. This is just the reality of couples having to wait 2 to 3 years to get married. Lots of things happen in that time period. Finally, although we want to believe that COVID is over, unfortunately, it is very much still a real thing, and clients are either getting sick or their immediate family is getting sick very close to the wedding and event date, and they are canceling for that reason. Now, I want to talk about, is force majeure still applicable for COVID cancellations and cancellations that are really involuntary by the clients? What's happened over the past couple of years is clients are really well informed about a force majeure clause. They know what it is, and they're just going to try to invoke it for any reason whatsoever. However, I cannot be clear enough that force majeure is not applicable to COVID anymore because COVID is not unpredictable and unforeseeable. It definitely is. Force majeure is for things, big, monumental things that are outside of both parties' control at the time of contracting. So I'll say it here, the rise in inflation in the economy are not force majeure events. Generally speaking, force majeure events are ones that are completely unavoidable. So not something like an injury that could have been prevented if they wouldn't have been risky and climbed up that mountain and went on a hike and broken their leg. Force majeure events are things like hurricanes and avalanches and war and terrorism and things along those lines. Think monumental and huge. It's something that a party, an impacted party, cannot recover from quickly. And what's key here is that it has to be completely uncontrollable and involuntary. If they're voluntarily canceling, force majeure is not a thing whatsoever. Thus, specifically, a client canceling on you just because they can't afford your services anymore is a voluntary cancellation, not a force majeure event. They sign contracts with all of their vendors, and now they are trying to sneakily find a way around trying to cut their vendor list down, trying to cut costs, or find less expensive vendors now when they already have signed contracts with you well in advance. Also, clients will want to enforce a force majeure clause when they're sick or ill or someone in their immediate family or immediate wedding party is. That is not a force majeure event. That's still a voluntary cancellation by the client. Becoming sick or injured is absolutely a foreseeable situation in everyday life, and it's not an act of God in a force majeure event. All to say, your client should not be canceling your contract just because they feel like it, or they no longer want or need your services. If it's an involuntary cancellation, it has to be a legit reason to cancel. And I would say nowadays, those are far and few between. So don't let your clients walk all over you and try to persuade you to do a different cancellation policy than what your business practices and contract actually says are your cancellation policies. So how do you deal with cancellations? First and foremost, please enforce your contract. If your contract says that your retainer or reservation fee is non-refundable under any circumstance, then don't refund it. If your contract also states that all fees paid up to the date of cancellation are non-refundable, then don't refund them. And if your cancellation clause says something along the lines of, you cannot cancel within 30 days of the event date, and if you do cancel within those 30 days, then your final invoice is still due. And here's the kicker: send over that final invoice. Don't just waive a provision in your contract simply because you know they probably won't pay, since they likely already told you that they're way out of budget, if that's the case of them canceling. Thus, still tell them, per our contract in Clause X, my cancellation policy states that if you are canceling within 30 days of your event, all payments are still due. Thus, I will be sending you your final invoice. Then send the final invoice. Obviously, it's probably unlikely that they're going to pay, right? If they are hurting on funds and they're canceling for that reason, then your invoice is probably going to sit open for a while. But at least you're taking the very first step in enforcing your contract. Then it's up to you on how far you want to go in trying to enforce that final invoice, and I'm going to talk about that in just a little bit. However, this sets a much needed precedent for you that you have a contract for a reason, you have a cancellation clause by your client for a reason, and that you're abiding by your own contract. Side note here, I wouldn't close out that open invoice for at least 60 to 90 plus days, because oftentimes what happens is you end up seeing your clients have their wedding and event, even if they told you they're full-blown canceling it and they didn't tell you that they're trying to just cut down on vendor costs, and then they have it with another vendor, and then you have way more of an argument on your side to explain that this was clearly a voluntary cancellation and they still had the wedding and event date and lied to you. This is a really good argument for you to be able to take them to court or collections for that final payment due. Also, make sure that you go back to your inbox and all of those potential clients and inquiries that came in for that specific wedding and event date and document those. If you do try to enforce that final payment or take it to small claims court or collections, you will want to show that you absolutely lost work for reserving that date on your calendar. And now I want to get into a question that keeps popping up regarding services not rendered and is charging that additional fee punitive in some way. This is a myth that I see being told time and time again, especially in Facebook groups. So listen up here. People think that because services weren't rendered, you can't enforce your cancellation policy regarding non-refundable retainers and reservation fees and cancellation fees. This is not true. Your client knowingly entered into this contract with you and signed on the bottom dotted line. And they know that by voluntarily canceling, they are probably going to be forfeiting some payments here. For example, in the Legal Paige wedding photography template contract, we have language in the cancellation by client clause that says that they have to give you notice before 30 days, or even if you want to put 60 days before the event date, that only the non-refundable retainer would be kept by you and that no other future payments would be due. But if they cancel within, say, those 30 days, then all payments are due under the contract. Legally speaking, if your contract says that this is your cancellation policy, then you absolutely can keep fees paid, and you can also invoice clients for fees due. This is why a notice provision in your cancellation clause is so critical, because that date and time frame is how you're going to argue this to a court. And if your client didn't cancel within that permitted time period in your cancellation clause, then you are entitled to those fees and can keep those fees. This whole argument on no services have been rendered really goes back to a force majeure argument or a non-voluntary cancellation. And what I am seeing is because clients are so used to doing this over the past 2 to 3 years, they're really going to try to hang their hat on that point. But it is not appropriate anymore for people to say that is the legal answer, because it's not. This is just a voluntary cancellation in most cases. Now, there may be a moral or ethical answer that may be different depending on the facts and circumstances of your client's canceling. But here, this is purely a simple, plain language reading of the contract terms and your cancellation policy, whereby your clients are voluntarily canceling, stands. And you absolutely do not have to refund, despite what some people are saying in Facebook groups. If the clients are voluntarily canceling on their own accord, then all of the fees paid are liquidated damages and are stated as such under your cancellation clause for that very purpose. Essentially, you are out income for the entire day that they booked with you, and it is virtually impossible for you to book another wedding or event date within 30 to 60 days of that date, because everyone else already booked their vendors well in advance. This is why wedding and event vendors and service providers to this extent have cancellation clauses in their contract. The same thing goes for hotels or Airbnbs or other service type providers that you see out there. Even if services aren't rendered, even if the Airbnb isn't used, you can't just cancel an Airbnb the week of or the month of if that's the Airbnb host's cancellation policies and expect to get a full refund. That's just not how it works if you're voluntarily canceling. You signed up for their cancellation policies. You'd simply be out the money that you paid the hotel or Airbnb, say if you canceled within 7 days of the date that you were supposed to be using the Airbnb or hotel, even if you didn't stay there. You have to abide by their business policies, the hotels or the Airbnbs, just like your clients have to abide by your cancellation policies. There is an opportunity cost to you for them canceling so close to the date. Also, same goes for rental agreements for things such as long-term rentals. And many of us have experienced this before with landlord-tenant situations. Courts have ruled time and time again that tenants are absolutely subject to cancellation policies in the contract. Although renters and landlords are subject to the burden to mitigate damages and try to find a new renter to go into that space, if they don't find a new renter, then the old renter is absolutely still subject to the cancellation policies and has to make payments due. All to say, if you have a clear cancellation policy in your contract that is reasonable, courts will absolutely respect that and abide by it. When your client voluntarily cancels, simply put, you lose business. There is a reason that service providers, specifically in the wedding and event industry, book so far out in advance. They say no to other potential bookings that come in. And like I said before, this is a massive opportunity cost to you. And as stated previously, it's likely virtually impossible for you to try and book a new full wedding and event date on that specific date that your clients are canceling. You may try to mitigate damages in some way by booking a few sessions on that date, say if you're a photographer, but for DJs and florists and caterers and cake bakers, that is really impossible to try to find a new wedding and event date because those weddings and events already have their vendors lined up. And they did it like 6 to 12 at least months ago. So legally, while it would be better for you to at least show that you tried to mitigate damages, you really aren't legally obligated to do all kinds of different things and bend over backwards to try to mitigate damages. Not only that, but you already put in work for this client with inquiry time and discovery calls and invoicing and planning and communication and prepping and sending out things to them probably. All of this is work performed. And those are payments that are due above and beyond the non-refundable reservation fee, because that reservation fee is only for booking out that date on your calendar, whereby now you already have additional work performed beyond that. Thus, you are entitled to keep fees set out in your contract. However, I will say that legally, your cancellation policy has to be reasonable. Based upon case law I have seen, a traditional wedding vendor probably couldn't have a cancellation policy within 90 to 100 days of the event date, whereby they have to notify you of, and that be a reasonable time period for them to cancel within for you to get all fees paid. This is likely not going to hold up in court because you absolutely have time there to try and mitigate some damages. Now, wedding planners in particular are a bit different here because there's so much work that is done prior to 90 and 120 days. But I digress there. Let's get back on track for all different wedding and event vendors. That's really a total facts and circumstances argument depending on the services you're providing. But a 14 to say 60-day cancellation policy is absolutely reasonable to have in your contract, especially since you have to do work prior to the event and prepare in advance. And within that time period, again, it's really hard to mitigate damages. Here's the main point that I'm trying to make here. If your cancellation policy and cancellation clause was really unenforceable, then why do you even have a contract? Why do you even have a cancellation or a rescheduling clause? Why do you have these business policies to begin with? They are there to protect you. And especially for the wedding and event industry that's so unique and niche, we book out so far in advance for a very specific reason, because clients have to line up their vendors or vendors are all gone. And they like to plan and prepare, and events just can't happen overnight. It takes time to make those come to fruition. Your clients can't just do whatever they want and cancel or reschedule whenever they want without some type of policy in place for them to hopefully be incentivized not to cancel or reschedule. That's your business policy. You don't want to just be out money and out a loss all the time and your clients calling all the shots. Your contract is there for a reason. Your clients don't dictate the shots. It's your business and your business policies. And cancellation clauses are absolutely enforceable in the eyes of a court. And you should respect and enforce your own cancellation policies as well. So what will it take to get paid for an open invoice by a client who canceled? Let's say you have a 30-day cancellation policy in your contract, and your clients come to you and cancel within 17 days. You've also sent them that final invoice, but it's been left open and they haven't paid it, and now you know why. They're canceling. So you do what I suggested earlier, and you have that invoice already sent to them, and you tell them, per our contract, you are canceling within 30 days and you are subject to all payments due. So you need to pay this final invoice that I sent to you. There are a few things that will probably happen at this point. You can continue to email them. I would suggest at least email them 2 or 3 more times and send a final cancellation letter via certified mail, perhaps. And although it's probably futile 99% of the time for them to pay that final invoice, what you are doing is documenting that you are enforcing this provision of your contract. They canceled so close to the event date, and you have a huge loss now. And I would bet that many of you within, say, about 90 days would probably just close out that invoice as unpaid and take it as a loss. Because lots of people think that taking them to collections or small claims court is really an uphill battle. But I want to caution you on that because you're setting, honestly, a precedent for all future clients that you will send the invoice, but you're just going to waive it in due time. And you don't want to do that. You want to enforce your cancellation policy. So while it may make sense to do that for some clients, here's what I would suggest for the majority of all of your other voluntary cancellations. Hold your ground and take it to small claims court and try to get compensated for your loss, especially if they are just trying to book a cheaper vendor and then you have documentation of that. Small claims court is a unique platform, and I'm not sure why, but in this day and age, many people online and in Facebook groups are saying never go to small claims court. It's not worth it. That's really not the case. It is a unique platform. It's there for a reason to protect small businesses just like you so that you have some type of recourse. You have some type of legal court you can go to try to show that there was a breach of contract here. Small claims court is for any claims around 5 to 10,000. You need to check in your small claims court and jurisdiction what the maximum amount of the contract can be. And you don't have to have an attorney to represent you. You can represent yourself, which is called pro se. And the barrier to entry to small claims court actions is very small. Usually it's a very minimal filing fee. So if you have to file this court case for maybe around $100 to $150 or less, I would say if you're out thousands of dollars, that is absolutely worth it. And then when your court date comes up, you just go to the small claims court and in front of the judge or the magistrate or whichever presiding person is there, you would present your contract, bring all of your documentation, and state in very clear, plain terms, leave emotions out of it, what happened, why your clients canceled, and why this is liquidated damages and an opportunity cost to you here, and you are out that money. And they now need to pay you this final invoice because they are the ones who voluntarily canceled on you. This sets that really, really needed precedent for you that you not only take your business seriously and you're not just going to waive contract provisions, but that you know what your contract says, that you are a business owner who will enforce their contract. You're having your clients sign these things for a reason to begin with. If not, why even have them? And here's a final tip for you. Sometimes just the threat of going to court is enough for your clients to pay you. If they get served papers that you have filed a claim against them in small claims court and now they have to appear, they probably are going to pay that invoice versus just showing up. And even if they don't, at least now you have all of the arsenal at your disposal to make very, very well-educated and knowledgeable arguments in front of that small claims court presiding judge. But I can promise you, no one likes going to court, not even your clients. So oftentimes this really does precipitate payments here when you file in small claims court. Lastly, is enforcing your cancellation clause in your contract always a good idea? Obviously, for voluntary client cancellations, absolutely. But there are some involuntary situations that you want to kind of tread lightly with. Sometimes there are circumstances such as death or serious illness or injury or an emotional circumstances whereby if your clients are really close to you or you've worked for these clients before, your customer service and word of mouth referral may not really make sense for you to enforce your cancellation clause. But again, I just want to tell you here, it's not that you can't enforce it. It's just that you're choosing not to. But I would really only do that in very limited circumstances because you don't want that to be the norm. Think here, death of the father of one of your clients or a really bad car accident. Emotional things like breakups and sometimes a weird illness that's happened in the immediate family whereby the wedding and event could still occur, but that person just can't attend. That may not be the best situation for you to waive a provision. I would say still enforce your cancellation clause under that circumstance. But maybe what you can do is give a little bit back to your clients. Maybe you're enforcing your cancellation clause, but you're allowing them to say transfer all their fees for 6 months or 12 months. So all of the fees that they've paid, and maybe they've paid their final invoice as well. So all fees have been paid here. And there's a really bad car accident, say 7 to 14 days prior to the event date. It is a cancellation under this situation, but you're going to waive the provision whereby the contract is completely terminated and then they have to start all over again. Maybe you'll allow some wiggle room there and transfer of all fees paid for a little bit more time for them to try to have their wedding and event date with you again. Okay, I know this was a really long video, but I think it was really important to flesh out all of this legal information. If you want more information on cancellation best practices, check out this podcast episode that I recorded right here, and it's linked in the description box as well. And I wanted to note that when a cancellation occurs, what you need to do is have your client sign a cancellation contract. The legal page has a cancellation contract bundle for when your clients cancel, and then also when you have to cancel as a service provider for whatever reason. These are really good legal documents to add to your legal toolkit as the chief legal officer of your small business. In sum, a cancellation by client clause is absolutely crucial to have in your contract as a service provider. And if you're a wedding photographer listening to this, speaking of really important clauses, I have a video that just popped up here on the screen that you'll want to take a look at next for not only a cancellation clause, but all of the other essential clauses that you need to have in your photography contract. And I'll see you over in that video. And if you have any additional questions regarding cancellation clauses or cancellation situations, please put them in the comments of this video.